Hey everybody, welcome back. Jeff Althaus with Althaus Law. I'm an estate planning and probate attorney, and today we're talking conservatorships. So get excited. This is a topic that not many people know about. Now, in Colorado specifically, conservatorships mean a court-appointed financial power of attorney. We have videos on financial power of attorney if you want more of a description of that. Long and short of that is, you're appointing someone to make financial decisions for you if you can't. If you do not have a proper estate plan, and you have not named a financial power of attorney, a judge is going to come in and name that person for you. We call that hearing a conservatorship hearing, and we call that person a conservator. Kind of makes sense. An easy way, like I said, to avoid all of this is have a financial power of attorney. So keep that in the back of your mind as we go through the conservatorship and the conservatorship process. So I said conservator is a court-appointed person named to make your financial decisions. Well, in order to get to that point, we have to go through the conservatorship hearing. Now, that can be a $5,000 to $10,000 hearing where you have a stranger, a judge, appointing a professional who's also a stranger and has no idea how you manage your money. That person's now going to be in charge of all of your money and your assets. They're going to be your conservator. That person could be a professional. It could be a family member. It could be one of your family that you would never want dealing with your finances ever. It's just up to a judge to make his or her best determination as what is in your best interests. You don't have to leave that up to a judge. Just do a plan in advance. Save yourself a ton of time and money, and your family a lot of stress and money, because that hearing, super expensive, super time consuming. And not only do you have to pay the $5,000 to $10,000 for the hearing, you've also got to pay that conservator an hourly rate. And depending on if it's a professional or not, that could be an attorney's hourly rate. If it's a family member, they could still take a fee as well. It's less likely that a family member would, but it is a hard job and it's very involved. Not only do you have all those downsides in a conservatorship, but there's also court requirements such as reporting periods. There's a lot of timelines and deadlines that your conservator has to meet. And it stretches out throughout your entire incapacity. So in order to have a conservatorship, you do have to be incapacitated. Very similar to a guardianship. That's more so for your medical stuff. We have another video on that, so check it out. But have this person appointed, and it's for your entire incapacity, so that could be the rest of your life. So if you can imagine how many years that could be, and how many hours a person is going to be working, and then multiplying that by their hourly rate. I have seen that wipe people's estates out. It's not a cheap process. So light at the end of the tunnel is you can avoid everything I just said by having a good estate plan, putting a power of attorney in place. That stops most conservatorship hearings. Good thing to keep in mind, I know I mentioned in Colorado we do things a certain way. Each state is different. And some states call a conservatorship a guardianship, and some states call guardianship a conservatorship. Here in Colorado, a guardianship is for medical things. A conservatorship is for financial matters. I don't know why some states flip it around just to confuse people. Sorry, I didn't make the laws. That's the long and short of conservatorships. If you want to know how to avoid them, watch our video on financial powers of attorney. Check out any of our other videos, like, subscribe, do all that jazz, and thanks for watching.